Welcome to episode 82 on the law report. Today's episode is going to be about the basis of plea in criminal proceedings. And this issue arose because I was asked to explain it by a client. And although this matter has no bearing on that client, he heard the term whilst in court and he sought some explanation as to what it meant. Now, before I get into the subject matter, my usual disclaimer: this is not legal advice, should not be considered as such. For legal advice, please contact an attorney of your choice. Welcome back. At some stage in a criminal matter or in criminal proceedings, during the criminal process, a defendant who is charged and before the court for criminal offense or offenses will be asked to plea, or in other words, the indictment or information or charge would be read or put to the defendant and you will be asked to plead guilty or not guilty to the charge. A defendant may choose to plead guilty to a charge for a variety of reasons, but in my view, the only reason the defendant should choose to plead guilty to an offense is because he or she is in fact guilty of committing that offense. However, if a defendant accepts his culpability and decides to plead guilty for that offense, it is prudent that the defense lawyer should contact the Crown or the prosecutor and set out a basis on which the defendant proposes to plead guilty. A defendant may choose to plead guilty on a basis that mitigates the aggravating factors in the Crown's case. In doing so, the defendant may be able to get a less severe sentence than if the aggravating factors were a highlight in the sentencing process. So, a defendant who pleads guilty to an offense can do so on a basis, meaning that it is accepted that a crime has occurred, but in circumstances different to those alleged by the prosecution, or without some of the aggravating circumstances alleged by the prosecution. For example, a defendant can plead guilty to an offense of assault, but on the basis that a weapon was not used as alleged by the prosecution, or he or she may plead guilty to possession of a firearm with intent to cause fear, but deny that he or she was waving the firearm around as alleged by the prosecution. The process for the basis of plea is that the basis of plea is normally communicated by the defendant before arraignment or before the charge is put to the defendant. And if the prosecution agrees and accepts the plea, on that basis, it should be reduced in writing and signed by both the prosecutor and the defense counsel, and then provided to the court or to the judge at the time of arraignment or at the time when the charge is put to the defendant and when he or she proposes to plead guilty. If the court accepts the basis of plea, because the court has a discretion whether or not to accept the basis of plea, but if the court accepts that basis of plea, then the defendant will be sentenced according to his basis of plea. In the event that the basis of plea is not accepted, either by the judge or by the prosecutor, because there are disputes in certain factual matters, what is called in Newton hearing, also known as a trial of issue, will be scheduled by the judge, and the evidence will be adduced from both the prosecution and the defense, and the judge will make a determination on the issue. So, to put this in context, in circumstances, the law allows for a form of plea bargaining where the prosecution agree in writing with the defendant that the defendant will plead guilty for a charge and a certain basis, could even be to a lesser charge than the one in which he or she was originally charged. This basis of plea should be set out clearly in writing. Now, where the defendant pleads guilty but disputes the prosecution account of facts, as previously indicated, the judge should order in Newton hearing. This hearing should proceed immediately unless impracticable for some exceptional reason to do so. The judge should direct himself in a way which reflects the relevant direction he would have given to a jury and reach his conclusions based on the evidence before the court. Now, in the event that everything is smooth sailing, the Crown agrees to the basis of plea, the judge accepts it, the defendant pleads guilty. Then the second stage is the sentencing. And based on the basis of plea, the defendant will then be sentenced. There are guidance that before the Crown accepts a basis of plea, that the Crown should consult with the victims or the complainant in the matter to get their feedback and to explain why the Crown would be accepting the plea, especially if it's on a different basis than what the Crown has alleged in its papers. But that, in a nutshell, is what a basis of plea is. And in many cases, it is beneficial to the defendant, as it sets out clearly the basis on which he's pleading guilty and the basis on which he's accepting culpability. Here is where I will leave this short episode for today. I thank you for watching, and I will see you very shortly in episode 83.
Thank you for watching another video on the law report. Please like, share, comment, and most of all, thank you for taking the time out to watch this video. See you in another episode.